We have Professor Marin Trybuss from the University of Birmingham, and we want to ask him some questions about the main issues in public procurement law in UK.
Well, I would say that there are a couple of interesting things going on at the moment in the United Kingdom, or I should rather say in England and Wales, because that is the main jurisdiction. There are other jurisdictions in Northern Ireland and in Scotland as well, which to a certain extent have a separate life and a separate development. But an interesting development, certainly both in England and Wales and Northern Ireland, is the increase of court proceedings against public procurement decisions that has been occurring over the last few years, perhaps 3, 4, 5 years. The tradition has been in the past that there have not been many cases brought against procurement decisions. There has even been a review a couple of years ago, the Wood Review, that inquired why, in contrast to countries such as Italy, France or Germany, where large proportions of the contracts that are covered by the EU public procurement directives and their transposing national laws, where they are actually challenged in courts, why there haven't been so many cases in the UK. And with not so many cases, I mean 1 case, 2 cases a year, sometimes no case at all. Certainly one of the reasons is that you have to bring your case to the High Court, which is a rather high level, and it's quite clear that what you need there as well is good legal representation, which always costs a lot of money, and that therefore the costs are so high that you would not like very much to actually initiate proceedings. Another one is a phenomenon of don't bite the hand that feeds, and that would mean, okay, a mistake has been made, the law has been violated, but I will not bring proceedings in a court of law because I would not like to upset the contracting authority in court and lose chances for the next contract where I might be more successful. And it has also been argued that generally perhaps the English do not like to litigate, bring court proceedings, especially against the government or against local authorities, as much as the Italians and the Germans and the Americans like to do that. But that seems to be changing, seems to be slowly changing, and I'm not saying that now we've got 1,000 cases as we might have in France, but certainly 5, 6, 7 cases. Perhaps there's now a body of several dozen cases, and that begs the question, and perhaps also makes it necessary to do another review, why there has been such an increase in these cases. And certainly one of the reasons is that the so-called Alcatel standstill period was introduced. That basically means that in the UK, like in other EU member states, there now has to be a standstill period of, on average, 10 days between the award of the contract and the actual conclusion of the contract, conclusion being an EU law term. In English law, you would say the making of the contract, and that this has actually opened the opportunity to use these 10 days to bring proceedings. So it seems to be also, to a certain extent, a practical question. But perhaps it would be interesting to do some empirical research and to see whether English companies have changed their cultural attitudes as well, and why they are now more willing to bring proceedings. Perhaps they don't want to lose a contract, they're financially too important, so they bring proceedings to have a chance on that individual contract. Or perhaps they're not as peaceful anymore, and they're becoming more like their colleagues in Italy or Germany. So it will be interesting to see more case law brought to the courts of England and Wales. By the way, Northern Ireland, the High Court there seems to be particularly busy with court proceedings. And to see whether behavior and litigation changes. That is interesting for many reasons. For the efficiency of the review system in general, because of course there are questions. You have a review system with a requirement for effective remedies, and there are no cases, so that might be a problem, although you could also argue, well, that is exactly not a problem, that just shows that the law works very well. And it would be interesting to see why people have changed their attitudes. Thank you very much.